After making this observation, the trial judge then concluded that Secretary E. challenging errors, new trial. 1099. The verdict must be set aside and a new trial ordered as to both the liability and damage aspects of the case. Although other points have been raised in this appeal, we believe the determinative issue to be whether the trial judge, when faced with this situation, abused his discretion by granting a new trial. The purpose of vesting the trial judge with power to grant a new trial is to permit him, before losing jurisdiction of the case, to correct errors that he or the jury might have made during the course of the trial. Courts or review have repeatedly stated that they will not disturb the decision of a trial court on a motion for new trial unless a clear abuse of discretion is affirmatively shown. The reason for this rule is that the trial court has had the opportunity to consider the conduct of the trial as a whole, and therefore is in a superior position to consider the effects of errors which occurred, the fairness of the trial to all parties, and whether substantial justice was accomplished. Greater latitude is allowed a trial court in granting a new trial than in denying a new trial. Plaintiff argues that defendant has waived his right to complain of the form of verdict because he did not object to the giving of this form to the jury but raised the issue for the first time in his post-trial motion. In most instances this would be a valid argument. Here, however, because of the single form of verdict, the jury's determination of liability and damages on each of the two causes of action was not made known. The jury returned its verdict on the 21st of December, 1962, and the defendant filed his post-trial motion on the 15th of January, 1963, thereby raising this issue for the first time. It was impossible, then, for the court to reassemble the jury and instruct them to correct the error in the form of verdict. We are not holding, by this opinion, that the failure to submit to the jury separate forms of verdict in cases involving multiple causes of action should, in every instance, result in the granting of a new trial, but rather that in the situation presented here it was not an abuse of discretion for the trial judge to grant a new trial. The order of the Circuit Court of Lake County, granting defendant S. motion for new trial, vacating and setting aside the verdict and judgment, and denying defendant S. motion for judgment notwithstanding the verdict, is affirmed. Affirmed. Stoder, Justice, dissenting. As was succinctly stated in Hall v. Chicago and Northwestern RY Company, 349 IL.App. 175, 110 N.E.2D 654. We are not unmindful of the rule and cases which hold that the trial judge is allowed broad discretion in granting motions for a new trial, and that his actions will not be reversed. 1100 Trial Chapter 14. On appeal except in cases of clear abuse of such discretion, but this rule, like all others, has its limitations. A judge is not empowered to set aside a verdict in any case simply because he does not agree with it. In the instant case, the trial court's granting of a new trial was based upon a finding that the forms of verdict submitted to the jury were improper. It therefore should be our duty to examine the propriety of this finding in order to determine the limits which were self-imposed upon the discretion of the trial court. Upon thorough examination of the record before us, I am unable to find that defendant made any objection to the forms of verdict at the conference on instructions or at any time prior to his post-trial motion. Defendant's failure to object to the forms at the proper time as well as his later failure to show that he was in fact prejudiced compels me in the instant case to find that the trial court's finding was erroneous and defendant's motion for a new trial should have been denied. KK if Rob v. John C. Hickey, Incorporated. Circuit Court of New Jersey, Morris County, 1941. 19 N.J. Misc. 455, 20.2d 707. Liddon, Judge. The issues presented by the pleadings were the negligence of the defendants and the contributory negligence of the plaintiff's decedent. The jury was instructed concerning the applicable principles of law, in the course of which it was pointed out that if contributory negligence upon the part of the plaintiff's decedent had been established, the comparative degrees of the negligence of the parties was immaterial. The jury returned a verdict in the absence of the judge, and it was recorded at the clerk's desk as follows: the jury finds that there was negligence on the part of both parties involved. The evidence shown is that the defendant was more negligent than the plaintiff. We therefore recommend an award of $2,000 to the plaintiff Clyde J. Robb and against the defendants John C. Hickey, Inc., a New Jersey corporation, and Roger W. King. Both parties are dissatisfied with the verdict, the plaintiff with its substance and the defendants with its form. Plaintiff has a rule to set aside the verdict upon the ground that it is ambiguous, inconsistent, inadequate, and contrary to the charge of the court. Defendants, upon notice, move to mold the verdict into one in favor of the defendants and against the plaintiff, urging that it is merely informal and the intent of the jury to find for the defendants is clearly indicated. Sec. E. Challenging errors, new trial. 1101. Here the verdict finds both parties guilty of negligence, erroneously compares the degrees of their negligence and recommends an award of $2,000 in favor of the plaintiff and against both defendants. What then did the jury agree upon and intend? Did it find in favor of the defendants as is legally indicated by the first sentence, or in favor of plaintiff in the sum of $2,000 as is clearly indicated by the last sentence? The recommendation of an award to the plaintiff is pertinent to the issues, for basically the liability of defendants to plaintiff in damages was in question. It cannot be treated as surplusage and disregarded. Reading the verdict as a whole, it is self-contradictory, inconsistent and ambiguous. 1. Is left to conjecture and surmise as to the real purpose of the jury. It is defective in substance, not merely in form. The court may, in fact should, mold an informal verdict to render it formal, effective and to coincide with the substance of the verdict as agreed upon and intended by the jury, but this power is only exercised where the real purpose and intent of the jury clearly, sufficiently and convincingly appears. Where, as here, the verdict is uncertain or ambiguous, it cannot be molded. The court will not substitute its verdict in place thereof. This leads to the denial of defendant's motion to mold and is also dispositive of the plaintiff's rule. The latter will be made absolute and a new trial granted. Notes and questions. 1. Why is the verdict in Robb different from a verdict that recommends that the amount claimed be donated to the American Red Cross or some other charity? Can an argument be made in favor of a new trial in the latter situation? See Ruzidoff v. DeBolt Transfer, Inc., 251 par. Super. 208, 380.2d. 451, 1977, in which the trial judge's denial of a new trial was reversed when the jury verdict for defendant was rendered with reservations due to the evidence provided. 2. Suppose plaintiff brings suit for injuries suffered in an accident, allegedly due to defendant's negligence. The jury renders a verdict in favor of plaintiff but assesses damages at zero, although it is clear from the evidence that plaintiff has been badly hurt. May the judge enter judgment on the verdict. See Wingert v. Maryland Cass Company, 313 F.2d 754, 5th Sir 1963, and Pitcher v. Rogers, 259 F.Sup. 412, N.D.Miss.L 966, in which the courts answered yes. Can these decisions be reconciled with Robb? Would you agree that a motion for a new trial challenging a zero damages award as inconsistent with liability is waived when the moving party argues that the jury has rendered a verdict that contains two legal conclusions that are inconsistent with one another, but failed to object before the jury was discharged? In this situation, the Ninth Circuit has explained. 1102 Trial. Chapter 14. District Court judges are in a unique position to instruct the jury regarding the meaning of the law, including whether two legal conclusions by the jury are inconsistent. Where the jury's verdict is in no way internally inconsistent, there is no more basis for resubmission to the jury than in any other case in which a party believes the verdict to be inconsistent with the record. The usual procedures for overturning jury verdicts as inconsistent with the facts therefore suffice and may be used without objecting to the verdict before the jury is dismissed. Code v. Carlson, 596 F.3d 608, 611, 9th Sir 2010. Duck v. MGM Grand Hotel, Incorporated. United States Court of Appeals for the Ninth Circuit, 2003. 320 F.3d 1052. Hawkins, Circuit Judge. Fernando Duck, appeals the judgment arising from a defense verdict in favor of MGM Grand Hotel, Incorporated. MGM, in Duck's personal injury action in which there were 2 trials and 3 verdicts. MGM Cross appeals the district court's decision to resubmit the first verdict to the jury for clarification, because we find that the court was within its discretion in resubmitting the first verdict, but erred in ordering a new trial upon receipt of the second verdict. We reverse and remand with instructions to enter judgment in Duck's favor consistent with the first jury's second verdict. K. The first jury trial was held in 1998. Because Nevada's comparative negligence scheme awards damages only to those plaintiffs who are found to be 50% negligent or less, the jury was presented with a special verdict form in which it was asked to determine the relative negligence of each party. Nev. Reverend Stat. 41.141. Question 5 of the verdict form asked the jury to allot a percentage of the total negligence to the plaintiff and to the defendant. Following question 5, the jury was instructed that if it found the plaintiff to be more than 50% negligent, it should sign and return the original verdict and judgment would be entered for the defendant. However, if in question 5 the jury found the plaintiff's negligence to be 50% or less, it was instructed to answer question 6, which asked for a determination of damages. Despite these instructions, the verdict form returned by the jury, the first verdict, attributed 65% of the negligence to Duck and 35% to MGM, but still went on to award Duck $3.3 million in damages. The district court reviewed the first verdict and, before announcing it, resubmitted the verdict form to the jury, informing the jury that the verdict contained an inconsistency and asking it to continue its deliberations. Following 20 minutes of deliberation, the jury returned with a new verdict. Sec. E. Challenging errors, new trial 1103. The second verdict, apportioning 51% of the fault to MGM and 49% to Duck, but leaving the award of damages the same. The court granted MGM's subsequent motion for a new trial based on the inconsistency between the 2 verdicts. At the second trial, the jury returned a verdict for MGM. Duck appeals the new trial grant and the judgment based upon the MGM verdict in the second trial, claiming that the second verdict was legitimate. MGM cross appeals, claiming that the trial court should not have resubmitted the original inconsistent verdict, but should have discarded the damages award and entered judgment for MGM. In the alternative, MGM argues that a new trial was properly ordered. Although Rule 49A, dealing with special verdicts such as this 1, does not explicitly provide for resubmission in case of an inconsistency, we have held that, because the rule does not prohibit it, special verdicts are also subject to the practice. Embrace of the practice is based on the notion that resubmission promotes both fairness and efficiency. That principle was reaffirmed in Larson v. Niemi, 9F.3d 1397, 9th Sir 1993, when we held that the resubmission of an inconsistent special verdict to a jury, with a request for clarification, was within the district court's discretion. ID at 1402. Here, The inconsistency arose when the jury awarded damages to Duck, even though it found him more than 50% responsible for his own injuries. MGM argues that the jury contravened the verdict form S instructions to sign and return the verdict if Duck were found to be more than 50% negligent, and, as a result, resubmission was barred by Floyd v. Laws, 929. F.2d 1390, 1397, 9th Sir 1991, responses in special verdict given in violation of a stop here instruction should be disregarded. Floyd involved a 42 U.S.C. 1983 suit and pendant state tort claims, brought by a mother and her children against a municipality and its police chief ID. At 1392. The jury was given a special verdict form addressing each of the claims, and found the police chief liable for assault and false imprisonment ID. However, after the jury had been discharged, the defendant's counsel pointed out that the jury's answers to two of the questions were apparently inconsistent with one another. The jury answered no to question 13, which asked whether the plaintiffs were damaged as a result of the chief's actions. Following question 13 was an instruction which read, if your answer to question 13 is no, do not answer any further questions, but proceed to the end of this form and sign the verdict. If you answered yes to question 13, proceed to question 14. ID at 1392-93. Question 14 asked the jury to award damages, which it did, awarding the plaintiff $7,500. ID at 1393. The trial court declared the 1104 trial. Chapter 14. Answer to question 14 to be surplusage and entered judgment for the defendants. ID. We upheld the trial court's decision, holding that, as in the case of parenthetical comments, special findings issued in violation of the trial court's express instructions do not constitute legitimate or viable findings of fact. ID at 1397. Because the trial court was bound by law to disregard any answer to question 14 as surplusage, the damages award never became a part of the special verdict, and the trial court was faced with no apparent inconsistency. ID at 1399 to 1400. Floyd, however, does not address the situation where the jury is still available when the inconsistency is recognized. ID at 1392. Because the jury had already been dismissed, the trial court in Floyd was left with the option of either disregarding the jury's answers following the stop here instruction or ordering a new trial. Thus, we had no occasion to consider whether resubmission, if it were possible, would also be within a trial court's discretion. Hen the jury is still available, resubmitting an inconsistent verdict best comports with the fair and efficient administration of justice. Allowing the jury to correct its own mistakes conserves judicial resources and the time and convenience of citizen jurors, as well as those of the parties. It also allows for a resolution of the case according to the intent of the original fact finder, while that body is still present and able to resolve the matter. An entirely different situation is present where the jury has been dismissed. The dismissal of surplusage makes sense. It is certainly preferable to ordering a new trial, and is very probably the best available instrument to determine the jury's intent. Resubmission, of course, leaves open the possibility that the jury will reach an improper compromise verdict. However, we presume that citizen jurors will properly perform the duties entrusted them and will not construe resubmission as an invitation to subvert the law and contort findings of fact in favor of a desired result. St. A trial court is rarely entitled to disregard jury verdicts that are supported by substantial evidence. The Supreme Court has held that a trial court has a duty to attempt to harmonize seemingly inconsistent answers to special verdict interrogatories, if it is possible under a fair reading of them. A court may not disregard a jury's verdict and order a new trial. until it attempts to reconcile the jury's findings, by exegesis if necessary. KKK. There is little authority addressing the question whether harmonization is required across different verdicts, where a verdict has Secretary challenging errors, New Trial 1105. Been resubmitted for clarification. Indeed, resubmission necessarily means that there might well be a difference between the first verdict and that reached after resubmission. Such an inconsistency WDL usually be considered a proper correction of a mistake in the original verdict. However, even if the second verdict appears to the trial court to be an improper compromise, the Seventh Amendment requires the court to seek a legitimate explanation for a verdict that is not contrary to the weight of the evidence. Further, verdicts rendered pursuant to resubmission are readily amenable to the harmonization requirement. In this case, the second verdict is flatly inconsistent with the first because it apportions liability differently. However, this discrepancy is easily explained by the process of redeliberation. Resubmission of an inconsistent verdict is done with the sole purpose of allowing a jury to reconcile inconsistencies. This process is not simply restricted to correcting transcription errors, but also envisions a process of redeliberation. Such a result is possible only where the jury is allowed to resume its deliberations. Some inconsistencies may only be resolved if the jury reconsiders its answers in light of the instructions given to determine how its legally inconsistent answers can be properly reconciled according to its view of the facts. Once this premise is accepted, it becomes clear that a post-resubmission verdict can easily be harmonized with its earlier counterpart by reference to a wholly proper process of redeliberation. In this case, the second verdict was not internally inconsistent. The only reason the district court expressed in finding that a new trial was required was that the second verdict was the product of a manipulation of negligence percentages. The court did not consider the possibility that the jury came to a different conclusion as to the facts because it engaged in further deliberations and legitimately came to new findings of fact. This is precisely what the trial court instructed the jury to do. When the court resubmitted the verdict to the jury, it twice instructed the jurors to continue their deliberations. However, the amount of damages remained unchanged from the first verdict to the second. Therefore, it is still quite plausible that the jury changed the apportionment of liability because it redeliberated and either changed its mind or clarified its thinking. It cannot be said here that the jury was clearly seeking a predetermined result. As we have stated, the trial court has a duty to reconcile the verdicts on any reasonable theory consistent with the evidence, because it is possible to explain the inconsistency in a way that comports with the law. The District Court S. 1106 Trial Chapter 14. Decision to disregard the second verdict and order a new trial was an abuse of discretion. KKF. We order reinstatement of the second verdict and entry of judgment for the plaintiff, including such interest thereon as calculated by the District Court. Note and questions. Are there practical difficulties to resubmission in jurisdictions that do not require jurors to remain together constantly once the case has been submitted? Before allowing the jurors to separate, the court normally will warn them not to discuss the case with anyone outside the jury room and not to inspect sites referred to in the testimony or otherwise to obtain evidence. See Steckler. Management of the Jury, 28 FRD 190, 191, 1960. Is it realistic to expect jurors not to have some discussions of a case with other jurors or with their families? What should the court do if it learns that discussions have occurred? 3. Jury misconduct and the integrity of the verdict. Should a juror be permitted to impeach his or her own verdict? Under Lord Mansfield's rule, courts were barred from Rel 5dng on jurors' affidavits to revisit a verdict. See Vase v. Delaval, 1 Term R11, 99 Republic 944. KB 1785. In 1866, the Iowa Supreme Court became the first state to deviate from the Mansfield rule, holding that affidavits of jurors may be received for the purpose of avoiding a verdict, to show any matter occurring during the trial or in the jury room, which does not essentially inhere in the verdict. Wright v. Illinois and Mississippi Telegraph Company, 20 Iowa 195. 210, 1866. See also Woodward v. Leavitt, 107 Mass. 453, 1871. Almost a century later, in Sopp v. Smith, 59 Cal.2d12, 27 Cal.rptr. 593, 377 p.2d 649, 1963, the majority/s adherence to the Mansfield rule provoked a strong dissent from Justice Peters. Justice Peters acknowledged 5 reasons for adhering to the strict rule of exclusion. 1. The need for stability of verdicts. 2. The need to protect jurors from fraud and harassment by disappointed litigants. 3. The desire to prevent prolonged litigation. 4. The need to prevent verdicts from being set aside because of the subsequent doubts or change of attitude by a juror. 5. The concept of the sanctity of the jury room. But he saw the Iowa alternative as a better way to protect the integrity of the verdict without unduly intruding on jury deliberations. The Iowa rule is based upon the distinction between extrinsic or overt acts which may be corroborated or disproved, such as access. Secretary er.hat.t. Errors, New Trial. 1107. To improper matter or an illegal method of reaching a verdict, and intrinsic matters which inhere in the verdict itself and hence are known only to the individual juror, such as misunderstanding or prejudice. Because matters which inhere in the verdict, including the thought processes and motives of the juror in reaching his decision, are not readily capable of being either corroborated or disproved, they should be excluded. ID at 15 to 20, 27 Cal.rptr. At 595 to 98, 377 p.2d at 651 to 54. In 1969 the California Supreme Court in People v. Hutchinson, 71 calories. 2d 342, 78. Cal.rptr 196, 455 p.2d 132, 1969, reversed its prior stance and accepted Justice Peters' position that juror affidavits may be used in appropriate circumstances to impeach the verdict. Can you explain the distinction between extrinsic and intrinsic matters? For an example of the difficulties that can arise when the court accepts affidavits of dissenting jurors alleging misconduct of the majority, when only a majority verdict is required, see Johns v. City of Los Angeles, 78. Cal.app.3d 983, 144 Cal.rptr. 629, 2d dist.1978, hearing denied by 4-3 vote of the California Supreme Court. See Mackenzie 3 and Bromberg, Jr., Jury Misconduct, What Happens Behind Closed Doors, 62. Ayla.L. Revelation 623, 2011. Notes and questions. 1. Examine the language of Federal Rule of Evidence 606, b. 1, set out below. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the Juror 5F's deliberations or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment or concerning the juror's mental processes in connection therewith. But a juror may testify about 1. Whether extraneous prejudicial information was improperly brought to the jury's attention, 2. Whether any outside influence was improperly brought to bear upon any juror, or 3. Whether there was a mistake in entering the verdict onto the verdict form. A juror's affidavit or evidence of any statement by the juror may not be received on a matter about which the juror would be precluded from testifying. Does Rule 606 B. 1. Follow the Mansfield or the Iowa rule. In Pena. Rodriguez v. Colorado, 137 S.CT 855, 197 L.ED 2D 107, 2017, a Colorado jury convicted petitioner of harassment and unlawful sexual contact on a child. The empaneled jurors did not express any reservations based on racial or any other bias after repeatedly being asked if they could be fair and impartial in the case. Petitioner moved for a new trial based on affidavits of two of the jurors that during deliberations, a third juror had made statements. 1108 Trial Chapter 14. Establishing that his vote to convict was based on racial bias against petitioner and an alibi witness. The Colorado courts rejected the affidavits under Colorado's Rule of Evidence 606b, virtually identical to Federal Rule 606b, that prohibits juror testimony as to statements made during deliberations to overturn a verdict. The Supreme Court, by a 5-3 decision, reversed. Although the court generally praised Rule 606b, it held that in the special case of racial bias in a criminal action, the Sixth Amendment required the rule to give way to permit consideration of the affidavits. Should this same approach be taken in civil cases? 2. Jury misconduct can take many forms. See O'Malley, Impeaching a Jury Verdict, Juror Misconduct, and Related Issues, A View from the Bench, 33. J. Marshall L. Revelation 145, 1999. Often the question is not whether the conduct was improper but whether the error is so serious that the verdict must be overturned. Assuming that a trial court has before it the following sets of facts. What rulings should it make on motions for a new trial? A. The jury, after deliberation, was deadlocked 7-5 for defendant, but because, during trial, one juror learned of the death of a son and wished to return home, the jurors agreed to abide by the vote of the majority, and therefore, without further discussion, rendered a verdict for defendant. See Jorgensen v. York I. Smack Corporation, 160 F.2d 432, 2d Sir 1947, cert, denied. 332 U.S. 764, 68 S.CT 69, 92 L.ED. 349, 1947. What if the jury, although properly instructed, erroneously believed that a majority verdict was all that was necessary? B. After the case was submitted to the jury and the jury deliberated for more than an hour without reaching a verdict, the bailiff, on instruction of the court, took the jurors to lunch in a local hotel and supplied them with alcoholic beverages in moderate amounts. Shortly thereafter the jurors returned to the court and, after a half hour of deliberation, rendered a verdict. See Keeler v. Tanaka, 45 Hor. 457, 370 p.2d 468, 1962, denial of new trial. Affirmed by 3-2 decision. What difference would it make if one juror had become intoxicated? C. During a court recess, plaintiff entered an elevator containing 3 jurors on their way to lunch. Plaintiff initiated a friendly conversation with one of the jurors regarding the fact that some of plaintiff's relatives lived in the area where the juror owned and operated a drugstore. The conversation was short and nothing was said about the case. See United States v. Harry. Barfield Company, 359 F.2d 120, 5th Sir 1966, denial of new trial. Reversed by a 2-1 decision. There are many cases in which jurors have been charged with misconduct for holding unauthorized conversations concerning the case. Most of the decisions turn on the nature of the conversation regarding the case and the extent to which the juror might have been influenced in his decision. Does it make sense? Seki Chat J. Enging Errors, New Trial. 1109. To presume prejudice conclusively in contexts such as United States v. Harry. Barfield Company, above. Should every contact between a juror and a party or attorney, or between a juror and a witness, be considered prejudicial. C. Printed Terry Finishing Company v. City of Lebanon, 247 par. Super. 277, 299, 300. 372.2d 460, 469, 1977, unexplained contact requires new trial. In McDonough Power Equipment, Inc. v. Greenwood, 464. US 548, 104s.ct 845, 78l.ed2d 663, 1984, the respondent was injured in an accident involving a power mower manufactured by the petitioner. During the voir dire before the empanelling of the 6-member jury, the respondent's attorney asked a panel of prospective jurors how many of them had sustained or had immediate family members who had sustained any severe injury. The man who would become the foreman of the jury did not respond. The jury ultimately found for the petitioner. After judgment was entered for the petitioner, the respondent's attorney questioned the jurors and discovered that the son of the foreman of the jury had been injured some time before by the explosion of a truck tire, sustaining a broken leg. During the post-judgment interview, the foreman said that having accidents are a part of life and that all his children have been involved in accidents. ID at 553N.3, 104S.ct at 848N.3, 78L.ed2d at 669N.3. When the respondent's motion for a new trial reached the Supreme Court, it held that to invalidate the result of a 3-week trial because of a juror's mistaken, though honest, response to a question, is to insist on something closer to perfection than our judicial system can be expected to give. A trial represents an important investment of private and social resources, and it ill serves the important end of finality to wipe the slate clean simply to recreate the peremptory challenge process because counsel lacked an item of information which objectively he should have obtained from a juror on voir dire examination. We hold that to obtain a new trial in such a situation, a party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause. ID at 555-56, 104s.ct at 849-50, 78l.ed2d at 671. Justice Blackmun, joined by Justices Stevens and O'Connor, concurred, stressing that the decision should not be understood as foreclosing the normal avenue of relief available to a party who is asserting that he did not have the benefit of an impartial jury. ID at 556. 104s.ct at 850, 78l.ed2d at 672. Justice Brennan, joined by Justice Marshall, concurred in the judgment, proposing a different legal standard. 1110 Trial Chapter 14. In my view, the proper focus when ruling on a motion for new trial in this situation should be on the bias of the juror and the resulting prejudice to the litigant. More specifically, to be awarded a new trial, a litigant should be required to demonstrate that the juror incorrectly responded to a material question on voir dire, and that, under the facts and circumstances surrounding the particular case, the juror was biased against the moving litigant. Or a court to determine properly whether bias exists, it must consider at least 2 questions. Are there any facts in the case suggesting that bias should be conclusively presumed, and, if not, is it more probable than not that the juror was actually biased against the litigant? Whether the juror answered a particular question on voir dire honestly or dishonestly, or whether an inaccurate answer was inadvertent or intentional, are simply factors to be considered in this latter determination of actual bias. KICF. ID at 557-58, 104s.ct at 851, 78l.ed2d at 672-73. 4. New trial because the verdict is against the weight of the evidence. Read Federal Rule of Civil Procedure 59 and the accompanying state material in the supplement. Aetna Casualty and Surety Company v. Yates. United States Circuit Court of Appeals, 4th Circuit, 1941. 122 F.2d 350. Parker, Circuit Judge. This is the second appeal in a suit originally instituted to obtain a declaratory judgment with respect to the coverage of a policy of indemnity insurance. The company denied liability on the ground that the defendant Yates was engaged in the performance of a criminal abortion at the time he incurred the liability for which the recovery was had against him, and that such liability was expressly excluded from the coverage of the policy. The question as to whether the defendant Yates was engaged in such criminal conduct was submitted to the jury, and from verdict and judgment in his favor the plaintiff brings this appeal. There was testimony below from which the jury would have been amply justified in finding in favor of the plaintiff insurance company and the secretary challenging errors, new trial. Nil. Issue submitted, but the defendant himself was examined as a witness and, if his testimony is believed, he was guilty of no criminal act. No motion for directed verdict was made by the plaintiff, nor was the sufficiency of the evidence to sustain a finding in favor of the defendant challenged in any other way before verdict. After verdict, plaintiff moved for judgment non obstant verdicto and also for a new trial, on the ground that the verdict was contrary to the credible evidence in the case, and exceptions directed to denial of these motions constitute the only points presented by the appeal. Even if a motion for directed verdict had been made by plaintiff, it is clear that same should have been denied, as should also any motion for judgment non obstant verdicto based thereon. The motion to set aside the verdict and grant a new trial was a matter of federal procedure, governed by Rule 59 and not subject in any way to the rules of state practice. On such a motion it is the duty of the judge to set aside the verdict and grant a new trial, if he is of opinion that the verdict is against the clear weight of the evidence, or is based upon evidence which is false, or will result in a miscarriage of justice, even though there may be substantial evidence which would prevent the direction of a verdict. The exercise of this power is not in derogation of the right of trial by jury, but is one of the historic safeguards of that right. The matter was well put by Mr. Justice Mitchell, speaking for the Supreme Court of Pennsylvania, in Smith v. Times Publishing Company. 178 par 481, 501, 36 a 296, 298. 1897, as follows: the authority of the common pleas in the control and revision of excessive verdicts through the means of new trials was firmly settled in England before the foundation of this colony, and has always existed here without challenge under any of our constitutions. It is a power to examine the whole case on the law and the evidence, with a view to securing a result, not merely legal, but also not manifestly against justice, a power exercised in pursuance of a sound judicial discretion, without which the jury system would be a capricious and intolerable tyranny, which no people could long endure. This court has had occasion more than once recently to say that it was a power the courts ought to exercise unflinchingly. J. Talix supplied. In the same case, Mr. Justice Williams, in a concurring opinion, traces the history of the exercise of this power and sums up his conclusion as follows. As early as 1665, the courts at Westminster did precisely what we have done in this case, and for the same reason. The right of trial by jury was not then supposed to give to a successful party the right to insist on an advantage due to the mistake or the willful misconduct of the jury, no matter how grossly unjust, and 1112 Trial Chapter 14. Oppressive the result might be, but the supervisory control of the court in banc, sitting as a court of review, was promptly exercised to relieve against the miscarriage of justice. The exercise of this power was then thought to be in aid of trial by jury. ID at 508-09, 36 at 309. KK it. The distinction between the rules to be followed in granting a new trial and directing a verdict were stated by us with some care in Garrison v. United States, 4 Sir, 62 F.2d 41, 42, as follows: where there is substantial evidence in support of plaintiff's case, the judge may not direct a verdict against him, even though he may not believe his evidence or may think that the weight of the evidence is on the other side, for, under the constitutional guarantee of trial by jury, it is for the jury to weigh the evidence and pass upon its credibility. He may, however, set aside a verdict supported by substantial evidence where in his opinion it is contrary to the clear weight of the evidence, or is based upon evidence which is false, for, even though the evidence be sufficient to preclude the direction of a verdict, it is still his duty to exercise his power over the proceedings before him to prevent a miscarriage of justice. It is equally well settled, however, that the granting or refusing of a new trial is a matter resting in the sound discretion of the trial judge, and that his action thereon is not reviewable upon appeal, save in the most exceptional circumstances. The rule and the reason therefore is thus stated by Mr. Justice Brandeis in Fairmount Glass Works v. Cup Fork Coal Company. 287 U.S. 474, 481, 53 S.CT 252, 254, 77 L.ED 439, 443, 1933. The rule that this court will not review the action of a federal trial court in granting or den 5 ring a motion for a new trial for error of fact has been settled by a long and unbroken HNE of decisions. The rule precludes likewise a review of such action by a circuit court of appeals. Its early formulation by this court was influenced by the mandate of the Judiciary Act of 1789, which provided in Section 22 that there should be no reversal in either circuit or Supreme Court on such writ of error for any error. In fact, sometimes the rule has been rested on that part of the 7th Amendment which provides that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. More frequently the reason given for the denial of review is that the granting or refusing of a motion for a new trial is a matter within the discretion of the trial court, while an examination of the record has led us to the conclusion that the trial judge might very properly have granted the motion for new trial. We cannot say that his denial of the motion amounted to an abuse of discretion on his part, or that there are present any of the special Secretary ER.HAT.T.F. errors. New trial 1113. Circumstances which would subject his action to review by this court. The judgment appealed from will accordingly be affirmed. Affirmed. Notes and questions. 1. In re Green S Estate, 25 Cal.2d 535,542 to 43,154 P.2d 692,695. 96, 1944. It is next contended by contestant that the court erred in granting proponent S motion for a new trial on the ground that the evidence as a whole was insufficient as a matter of law to support a verdict for respondents. The rules of law applicable to an appeal from an order of the trial court granting a motion for a new trial on the ground of the insufficiency of the evidence are well settled and, as stated in one of our most recent decisions, are as follows: when the motion is granted, as here, for insufficiency of the evidence, it is only in rare cases showing abuse of discretion that an appellate court will interfere, because the trial judge must weigh all the evidence and determine the just conclusion to be drawn therefrom. It cannot be held that a trial court has abused its discretion where there is a conflict in the evidence, or where there is any evidence which would support a judgment in favor of the moving party. Hams v. Rust, 14. Cal.2d 119, 123, 124, 92 P.2d 1010, 1012, 1939. We may not agree with the determination reached by the trial judge, or with any of his conclusions. That is not the question before us. It is his duty to weigh the evidence and to pass upon any and all conflicts existing therein. If after such an examination of the evidence he concludes that it is insufficient to support the verdict, his duty is to grant the motion and the reviewing court may not set aside his conclusion unless a showing of abuse of discretion is made out by appellant. As we have seen, if there is any substantial evidence in the case supporting the trial court's action, then we should not interfere with its order granting said motion. Under Green S. Estate, when may a new trial be granted? How does the standard differ from Eatnell? 2. In Marsh v. Illinois Cent. Arco, 175 F.2d 498, 500, 5th Sir. 1949, the district judge granted judgment notwithstanding the verdict, but denied an alternative motion for new trial, saying, "It is my judgment that the evidence was insufficient to go to the jury, but if I am wrong in that, then I do not think a new trial should be granted as there were no other errors of law." The Court of Appeals reversed. While it is not our function to weigh the evidence, we do agree with the trial judge's first expressed opinion that the weight of the evidence is overwhelmingly against the plaintiff. But we do not agree that the grant of a judgment notwithstanding the verdict was 1114 Trial Chapter 14. Therefore justified. There was evidence of the appellant, not very explicit or positive, which if believed might authorize a jury to conclude he was hurt in the manner he claims. Because the trial judge does not believe it, because of appellant's own contradictions and conduct and of opposing evidence which seem to overwhelm it, is not ground for a judgment notwithstanding the verdict, and we must reverse that judgment. But it is ground for the trial judge to grant a new trial, though the trial was free of other error. He has in strong terms disapproved the verdict as contrary to the evidence. We have reversed the entering of a final judgment, but it is evident that the new trial ought to be granted and would have been except for the misconception that absence of other error prevented it. The full discretion vested in the trial judge not having been exercised, we will remand the case with direction to the judge to grant a new trial if he continues to think the verdict to be against the overwhelming weight of the evidence. On remand, are there any circumstances in which the trial judge could decide that the verdict was not against the weight of the evidence? 3. How does the standard for granting a motion for a judgment as a matter of law, formerly called a motion for a directed verdict, differ from that of a motion for a new trial? In Dyer v. McDougall, 201 F.2d 265, 271, 2d. Sir. 1952, Judge Frank, concurring, said, "The well-settled rule is that, in passing on a motion for a directed verdict, the trial judge always must utterly disregard his own views of witnesses' credibility, and therefore of their demeanor, that he believes or disbelieves some of the testimony is irrelevant. When asked to direct a verdict for the defendant, the judge must assume that, if he lets the case go to the jury, the juryman will believe all evidence, including demeanor evidence, carried favorable to the plaintiff. In other words, the judge must not deprive plaintiff of any advantage that plaintiff might derive from having the jury pass upon the oral testimony. Indeed, the important difference between a trial judge's power on a motion for a new trial and on a motion for a directed verdict is precisely that on a new trial motion he may base his action on his belief or disbelief in some of the witnesses, while on a directed verdict motion he may not. See also Bowditch v. City of Boston, 101 U.S., 11 Otto, 16, 18, 25 L.ed. 980. 980 to 81, 1879. It is now a settled rule in the courts of the United States that whenever, in the trial of a civil case, it is clear that the state of the evidence is such as not to warrant a verdict for a party, and that if such a verdict were rendered the other party would be entitled to a new trial, it is the right and duty of the judge to direct the jury to find according to the views of the court. The Bowditch case is but one of many with language of this kind. 4. It often is said that the grant of a new trial is largely unappealable. In those systems that adhere to the final judgment rule, it can be reviewed by SEC e-Challenge MGERAS, New Trial 1115. Appealing from the judgment on the second trial, but in that case the appellant presumably